I'm Fabrice Bardsley. We're here today talking with Bradley Knight about his adventures in legal land and how to defend yourself from bureaucratic attack. Oh, Bradley.
Hi Fabrice.
Thanks for joining us.
Yeah,
You've been doing this for quite a while. Why did you originally, or how did you originally come to be involved in legal land and helping people in court?
Okay, initially how it all started is I had what I believed was a very strong case where I was suing somebody, and whilst I believed in basic principles of law, what I didn't realise is actually skullduggery can play in the courts, and technicalities play a big part as well. So the slant on a word, for example, could have an impact on your case, and the form filling process, which a lot of people don't complete correctly. So that's basically how I got started. I lost my case, and I went to appeal and lost the appeal. Now I didn't lose the appeal because my case had no merit, but I lost the appeal because I missed out certain facts. That was what is described as errors in law. So errors in law, and so that was a tough exercise for me, because I thought, you know, I had a really good case, and I still believe that to be the case. But effectively I lost, and I just couldn't believe how someone could win a case when they basically had no justification, no merit, but because of technicalities and the fact that I didn't complete certain stuff in the fashion that they want, I was quite aggrieved by it. But anyway, that was by the by. That was, you know, 10, 11 years ago. So I started looking into how I could appeal against the appeal, and I come to the conclusion, actually, I'm at the end of the road, I might as well just settle. And so that's what I did do. And then decided, actually, because I was in the court quite a bit through that claim, I started meeting other people, and they were telling me their stories. And naive as I was at the time, I kind of thought, that can't be true. That can't be true. You know, the stories I was hearing were horrific. And I started like focusing a bit more about the court system, because it intrigued me anyway. And so I started just turning up at court, just sitting there in the gallery, and I thought, I cannot believe I just heard what the barrister just said for the defence, and what the prosecutor said, and the standards they were setting. I was thinking, you know, just common sense. I was just thinking, God, I cannot believe this is happening. And some of the stories that people were telling me, they've got to be true. You know, really got to be true, and they were true.
So you're able to see firsthand how sometimes justice almost takes a back seat to the theatre of the technicalities of the judicial process. Yeah,
the way I kind of got the personality that I developed from it is basically, I know a lot of people believe in everything's a contract, right? Now, in essence, it is. And that's what I started to understand, and that's the route that I never went down, but I understood that basically that the obligation derives from a contract of whatever shape or form, of anything in life. It has to be, because otherwise nothing will exist in terms of there's no due process. And you look at the judges, and they get their white book out and stuff like that, and you think, well, they're saying, right, my contract is essentially says that I've got to follow this. That's where my jurisdiction comes from. And so I spent many hours just sitting in court, and then I started, like I say, people were talking to me and asking me why I'm there, and I said, you know what, in cases, I just said, well, if that was me, this is the way I would have done it. So I started evolving from that, and basically all I did was loads of research, and then started think, stuff it, I'm going to start helping people. What I always do, as soon as you get a ticket, a speeding ticket or whatever, I mean, obviously when you get, if it's stopped by a police officer, don't sign anything. You've got to make sure you don't do that. Now, it doesn't matter if you do sign it, doesn't really matter, because it's not basically, it's not acquiescence or anything like that. It's not an admission, it's just to say you got it, but don't sign anything, you know, and I would never say anything to the police. Regardless, you know, I just that's a commonsensical approach.
Well, they tell you that anything you can and say, anything you can and do say, when questioned about it,
can be used against you.
Against you, it's not used for you; it's used against you. So they're telling you, actually, if you want to do yourself a favour, say nothing.
You definitely got to follow, because the thing is as well, if you say, even if you're the most innocent party, whatever, just don't say anything, because you know you're innocent, and then let them prosecute or proceed on whatever lines they've got, avenues they've got. By you saying something like, for example, I was not speeding, you could have been speeding.
Yeah.
Or you know you weren't speeding, let them prove their case.
Yeah.
The burden of proof is on them. Now, it's not always the case nowadays, though, unfortunately, but that's the basic premise.
Okay, and the burden of proof is just to cover that, is who has to make their case, who the responsibility is on to prove their charge.
Provide evidence, facts and evidence. You know, it's not your.
Yeah,
it's
I mean,
not your
to
job
put
to
it
provide your
put
facts
it
of your
put it into a
innocence.
nutshell. It's called a valid cause of action.
Yeah.
That's basically it.
Yeah.
You know, is that it's their case, not yours. The way I go into court, to be honest, if it was me defending myself, I would say it's my case, but technically it's their case. But I go into court on the basis of my case.
Yeah.
You know, I don't care what they've got to say. It's my case. I'll do the talking.
Yeah.
Now,
That was kind of how we approached it as well, and the fact that I'd chosen to take it to the court.
Yeah.
So and I was there for a reason. So in the way that my hearing. It's
yes,
my hearing.
exactly.
You know,
Yeah.
otherwise,
yeah.
I'd have just.
I mean,
dealt with it outside.
obviously you get a summons, and if you don't get a summons, you're going to get a warrant for your arrest. So you accept the summons. I mean, a lot of people say ignore it, but don't do that. Don't ignore anything
Yeah.
in life. Don't ignore anything, because it only gets worse. Of any premise, relationships, whatever, you know, it's the same sort of thing. So I always respond and deal with everything. So the worst that can happen, I'd love to have it.
Yeah.
The reason being is I can deal with it.
Yes. It's
So-
always better to know.
Yes, exactly. So basically, I go to court. Let's just say for speeding, as we were just saying. The first thing I do is never plea. I know that's adverse to possibly your position, because I know you follow Mark Stevens sort of stuff.
Well,
We don't plea, no.
Yeah.
So we're unable to plea
we're
because we
never in
don't
a pos-
understand
Yeah.
the charges being made against us, so we're not able to make a plea, and then they enter a plea.
Yes, I always let them enter a plea, but also at the same time, we're talking about criminal in this instance, speeding. It's not criminal, sorry, illegal to speed. And there's a big difference between legal and lawful. Lawful is obviously the common law sort of element. Legal is obviously statutes and acts, which apparently we've all got an obligation to abide by. Fine, okay, I accept that. I'm not one of these free man type people, although I do believe in it, as I said earlier. So what I then do is get the prosecution to commit to disclosure.
Right.
And this is what you'd always hear, and I saw it, you know, I repeat it all the time, is you get them to put their cock on the block and say, look, we're going to give you disclosure by this date. Can I say that word? Sorry, I apologise.
Absolutely.
And they never do it. They never will do it. The reason being is CPS is under so much pressure. They've got so many cases. They haven't got a clue what's going on. They really haven't. All that happens is, and if you've been in the court environment as much as I have, is the CPS, they open their laptop or their file, most of the time it's on the laptop nowadays, and they just read off a script. If you know, this happened on this day, this happened on that day. You know, as far as I'm concerned, I don't give a crap what they've got to say. All I want is disclosure so that I can produce a proper defence. Now,
so in terms of CPS, would you say a couple of years ago that they were having problems being committed to prosecuting your case that they'd been given? Because the reason I ask is in the last couple of years, the CPS has had their budget cut by over 30%.
yeah.
So I feel that's a situation which is going to get much worse.
I think that's a bit of a myth in some respects, because what they do is flip it. They use a lot of subcontractors now.
Okay.
So they're using other law firms. So whilst the core budget, as in PAYE staff, has been cut, they're supplementing it with the other side, the subcontractors, which is off book, it's off balance sheet. So, and you know, I've seen it quite a lot. I mean, like in Hatfield, for example, which is a remand court there. I was talking to a lot of CPS lawyers there, and none of them were actually CPS employees. None of them.
Okay.
You know, I'm talking about 2 years worth of hearings which I've been, you know, seen, dealt with, and they're all subcontractors.
And so they don't have again the same investment in the case, in providing disclosure.
I can tell you some cases. I'm not joking. This is the personal first-hand knowledge of a case. For example, 3 Chinese-looking guys. I don't know if they're Chinese or not. They had funny names. They pulled up to the dock in the remand at Hatfield, and there's 3 separate CPS lawyers, all subcontractors, and they get to the third guy. So 2 guys got remanded. Third guy said. Because the other 2 got remanded because they said we'll plead guilty. The third guy his plea was guilty, but the first guy was the one that said he wanted to plead not guilty. Now, the point being is basically these CPS lawyers didn't even meet their clients.
Okay.
And they actually remanded the wrong guy. So guy number one wanted to plead not guilty, should have went home. The other two, and they realised when they got to the third person, was one that wanted to plead guilty and should have been remanded, so they had to call them all back up. I mean, how incompetent is that?
Yeah. Well, that's people's lives.
Yeah,
that they're,
yeah,
that
exactly.
They're,
Yeah, exactly.
They're messing
And
with.
And what I found was, until it got to an actual trial where they had to keep the same prosecutor, every time we turned up,
No,
it'd be a different one who
never
just
be the same
picked up
one.
the file
Never, yeah.
that morning. They didn't know anything about it.
I've seldom seen the same prosecutor.
Yeah, only once the
yeah.
trial has begun. If it's part heard,
Yeah.
then it has to be the same prosecutor.
The defence attorneys, I've seen generally they're the same.
Mm-hmm.
You know, I've got some really good relationships with some of them, especially at St Albans and at the High Court as well. But going back to this situation in court, magistrates' court, for example. So they ask you to plea. You said I can't plea. You don't say I'm not willing to plea. You say I can't plea, and they say, well, you're not willing to plea. We're going to plea on your behalf. Well, you say go away. Have the fun with it. The reason why I leave it like that is because all I'm thinking of, I'm going to lose the case and my appeal. Now, so you get the CPS to agree, I'm going to do disclosure with 28 days, which is standard, basically, and then the trial date gets listed. What happens is in 28 days, they don't provide anything, or if they do, it's crap. It's nothing that you want.
That's exactly our experience.
But basically, at the same time as well, I've got prepared what's called an effective case management form, which is downloadable on the web, just Google it. You should be able to pick it up. If not, contact Fabrice. I'll email him a copy.
Yeah, we'll pop a link down the bottom.
Yeah. And then you give them that. Now they'll be really surprised you've got that because they never complete it. But it's a mandatory statutory requirement. They do that, but they don't complete it. Now I'll tell you a story. Not too long ago, on one case, a lady called Elizabeth tried to be done for drunken disorderly. She slapped it on the CPS's desk. I mean, it went verbatim to what I said was going to happen, and they really surprised that she had this form, and I inadvertently, accidentally picked it up from a prosecutor's desk one day, about 4 years ago, and I've used it every day since. Anyway, she handed it to them, but this is what scumbags they are. They said that they couldn't fill it in there and then, that they'll send it back to her. This is her document. They can't touch it. What they did was they binned her copy and filled it in themselves and sent it on to her. So I said, go back straight for a mention hearing, ask them why they've amended her effective case management stuff, because she was getting done for drunken disorderly with her and her mates. I mean, she's like, I think she said she was like 60 or something like that. And it's not as if they're going out, to go and attack loads of people, but that's what happened. And apparently they weren't drunk. I believe them. So basically what we did, and this is the process that you should always follow, as soon as they're late on anything, go straight back to the magistrates or the Crown Court, whatever it may be, and go for a mention hearing. Really important. And then you say, they agree to do this by this date, I'm a litigant in person, I require this so I can then litigate myself and defend myself effectively. A lot of people don't do that. It's a tiny process, I know, and what will happen again, as in their case for example, is the CPS fail again, because they always do. They're incompetent.
That's every time we've seen that, and that seems like a great way of a lot of people when they have court hearings, they feel personal pressure. They have sometimes they have problems going to sleep. They're really worried and concerned about what's happening. It feels like they're taking that pressure. That way seems like a really great way of empowering yourself to take some of that pressure off yourself and put it back where it belongs on the people who are interfering in your life.
Yeah, exactly. You reverse it. But the thing is, what you're doing is nothing unreasonable. I mean, it's a bit like someone knocking on your door and say, you owe me £1,000. You're not going to just bend over backwards and say, okay, here's £1,000. You want to, I mean, my belief, speeding, to be honest, I mean, obviously, people should have morals. But if, for example, I don't know, you're on the motorway, doing, say, 80 instead of 70, my view is a guideline, that's basically my premise.
Yeah.
But if you're doing, say, 80, and you've got a car that can do easily 80, most cars nowadays can do 80 or 100 quite easily. As long as you're a safe driver, then you should be free to do free will.
My attitude is that I believe I take personal responsibility
Yeah.
for my driving. I don't believe I'm dangerous. I've never had anyone complain about my driving.
Yeah.
So yeah, an advisory, we recommend this speed, but to treat you as a criminal,
Yeah,
if you go
exactly,
over it when you haven't done anything dangerous and there's camera evidence that you haven't, you know.
Yeah.
It doesn't make sense.
You know, I drive. I got stopped for speeding doing. This is at Brent Cross, which is in London. Yeah, I don't know if you know it, but there's like a
centre there.
there's a slip road, which goes from off the motorway from the M1 onto I can't remember the name of the road, but it's towards Kilburn, and there's a little slip road there. But there's a section there, just this one section, which is probably, I don't know, half a mile long, which reduces to 30. But you're joining from the motorway off the roundabout to a dual carriageway, so you'd think you can go 50.
Yeah.
But it's only 30 at this specific point, so I got stopped there. And again, using my same process again, using the common sense approach, saying, well, the signs are not right, you know, who's the corpus that are the injured party, can I have full disclosure? And again, what happened is they couldn't give me proper disclosure on anything, really.
Yeah.
They had this camera, which was tested. It was one of those mobile ones, calibrated, that's the word I was thinking of. And they had all that sort of stuff. I said, well, okay, fine. So who's the complaining party? Who's the victim? All that sort of stuff. The usual. I was saying the usual. I don't generally go down that route because in my case, I don't mind having a bit of fun with it.
Yeah.
And eventually, the CPS just gave in. They just caved and said, okay, we're not going to pursue any more charges. And they used the same old adage: it's no longer in the public interest. And in fairness, it never was in the first place.
Yeah.
You know.
I think. What do you think about the way in which potentially with some of those infringements or alleged infractions that they're pursued for monetary purposes as revenue raising?
Listen, I believe. Okay, this is where I see society. We are in a police state. There's no doubt about it, right? Whether that's for monetary reasons or another, I don't know. The only thing I do know is that we've got egotistical police officers are no longer doing the job they should be doing. They're not corrupted in terms of malice, but they're just their mentality.
It's a brainwashing.
Yeah, it is. It changes
conditioning.
completely.
Yeah.
You know, and I've seen it so often. I've seen it in court as well. You know, you see it on various YouTube channels. I mean, what police officer would smash someone's car window for speeding or a potential cannabis offence or whatever? It doesn't make any sense. I mean, I saw a video of an old man who must have been about 70. He got tasered.
Yeah.
You know,
which is incredibly dangerous because a number of people have heart conditions and those things can.
But it just doesn't make any sense. I mean, if you just step back and look at it logically, why would you want to do that to somebody for, say, for example, for a speeding offence? Yeah. They've stopped. They don't necessarily want to be engaging with you, but okay, this, like say this old guy who got tasered, a space of 30 seconds he was on the floor tasered for a speeding offence. How ridiculous is that?
Yeah, and that's I think with things such as automatic number plate registration cameras, which are now encircling most arterial routes in most towns in the country. There's the number of cameras that can be used for smart roads, so they're actually monitoring where people go and what people do.
But this is why people don't see it so wrong, though. That's what frustrates me the most. That they're there for your protection, but if you think about it just logically, this is my approach, and I do believe in the non-aggression principle about everything. Right? I'm not a violent person. I probably can get a bit angry sometimes, but I'm not a violent person. But if you look at it from just a family perspective, a social perspective, how can the police justify their actions most of the time? I mean, for example, only a couple of weeks ago, I got arrested for attempted burglary, and there was just no logic to it whatsoever.
Yeah,
it was just no logic, and you're just thinking, well, the guys, the CRD officers that interviewed him in the morning after me spending the night in the cells, said to me, he said, well, why don't you just explain that to the police officer, because it took all of 5 minutes. And I said, well, it took me all of 5 minutes to explain to you, you understand it, why didn't they?
Yeah.
And they're using that stupid sort of discretion and logic where I've lost my liberty for that evening. I had stuff to do, not least sleep anyway, but also I had paperwork to do, but these police officers just didn't give a shit. They just thought, okay, well, yeah, his exact words were, "You're trespassing." I said, "Trespassing is not a criminal offence," and they said, "Okay, we're going to do you for attempted burglary," just like that.
Yeah. It's
And my tool of choice was a camera phone. This one.
yeah, that looks like a
That's going to get me far, isn't it?
yeah, you can burgle a lot with that, you know.
But you think about it, right? I luckily in legal land, I've been there, done it, and to be honest, I've sweated hard in it. But you imagine people that may have mental health issues or vulnerable people, and they're up against this all the time.
Yeah.
Well, you don't have to imagine.
You know how to cope with it because you've trained yourself to do it. But you know, there's so many people out there that are just getting.
They're just getting raped. They're getting raped.
They're getting abused and intimidated.
I think there was over 10,000 people with mental health issues that were placed in custody because they couldn't find the appropriate place for them. I think that was last year or the year before.
Right.
And of course, if you mentioned a few things there, one of them being, you know, the fear and the intimidation that can sometimes come from people in uniforms and people in court. And also how, when you're actually able to have some understanding of legalese, if you like, or the bureaucratic language, that you actually have more confidence and more surety in what you're doing.
I think it's once you've been there and you've seen it for yourself, you've actually played it out and you've seen that actually.
Yeah, I mean, one thing I will say,
is a big con.
as I said earlier, is I try to stay away from legalese, not because of purpose, but the only thing is that I believe in common language.
Yeah. And I don't believe in using it, but it's good to have a bit of an understanding of what they're actually saying to you.
For things like appeals, that's when you've got to get your legalese in, right? You have to, right? And that's where you use like and all that sort of stuff, right? Because you're trying to put a legal argument they've erred in law. But prior to that, you've got to stick to common sense language. Because the problem is, if you get too clever, like a lot of people do, they don't understand what they're writing. And then secondly, the judge is going to say, well, you clearly know what you're doing, and let's have a bit of fun. Because he's just going to rip you apart. Yeah. If you stick to common language, common basic understanding, you're in a far better position by arguing those sort of points. Yeah. And, you know, instead of going like, I don't know, like 1862 or go back to Magna Carta 1215 or whatever, just try and stay away from that.
Well, it's interesting because we came across this when they use those lovely Latin phrases. Now, I don't know about
they
your
use them out of
education,
convenience.
And when Helen used them in court, to take the Latin phrase, the translation, what it actually meant, and use that, because actually that's the real language. That
you just turn it around and clarify, is this what you actually mean, don't you?
You know, so
prima
facie, you know, does that
if
mean
you need to,
at first glance? You know.
Yeah, again, I stay away from it. But a great prime example in the UK, and I mentioned this the other day when talking to Mark actually, is the word objection.
I found that really interesting because you used the word stop.
I was listening to that as well. That sounded I thought they ignore the word objection most of the time.
Well, as I said, this is a judge saying, well, not in America, and they also use other terminology, whatever. And I said, you're objecting to me using the word objection. But what does objection mean? But they're saying that's not courtroom language. Legalese or whatever. But so, you know, I've adapted it, but I still go back to the word objection, because what does objection mean? Yeah. But then to them, and the ironic thing is, as I was saying on his show, was that I said, can you not see how you're objecting to me using the word objecting? Yeah. How circular is that?
Yeah. Or is that one rule for them and another for us?
Well, it's not even that.
I'm allowed to object to you using objection, but you're not.
So have you clarified with them what terminology they'd like you to use at the point you would like to interrupt?
This goes back to the point of how you try and work the courtroom. Is they will ignore you as you see fit, you ignore them as you see fit. And that's what I do. I just continue on regardless. Now, if it's someone else's case, and I think there's a risk of me upsetting the judge, I mean, I've been threatened with contempt loads of times. Never been done with contempt, but I mean, I'm saying loads, I mean it's in the dozens. Now, I don't do that on purpose, but I do it just to control the environment that we're in, to let the judge know that, you know, I'm not, you know, you can't take the piss. And that's important, but also you can't be too cheeky, because, you know, unfortunately, they do deserve a bit of respect. As I said before, I've told a prosecutor to call me Santa Claus, you know, and Your Royal Highness, and only because they're demanding stuff from me which I don't want to give. You know, like for example, Fabrice. If you were the prosecutor, I'd call you Fabrice, or I'd call you Helen. You know.
I had a magistrate threaten to get security to remove me from court for asking for his name.
Yeah, but I always ask for the name up front. The only reason why is because I want a record.
Okay.
I want to know everybody in the room, because it's quite easy just to get shoved into the process and you forget everything.
And I prefer to use their names if I need to put any paperwork in, rather than the judge.
It's really important you get all the details.
Yeah. But he was saying you didn't have to give it to me. I was saying, no, I'm afraid you do.
Yeah. What's really important, specifically at magistrates, though, that you get that information up front, because there's no record.
Yeah.
There is no record. I mean, it proved in a... I was at the High Court yesterday. Yeah, I was at the High Court yesterday. Sorry, that was the day before yesterday. And there was a guy who needed me to get an injunction against British Gas, and he had this warrant, which on the face of it wasn't particularly that didn't look like a warrant.
Okay.
And so I said I'll go and get an injunction. Now, the thing on that warrant is that when he spoke to the magistrates' court, Stroud it was, which is up north somewhere, it doesn't give you any details, doesn't have a case number and all that sort of stuff. So all the fundamentals, I mean, ignoring the stamp, the seal and all that sort of stuff as well, but essentially didn't have any of that information. So I managed to get the injunction. I did that ex parte as well, and also without the guy being there. So I did it all myself. You know, that was pretty cool.
So you find that the courts can be agreeable to you doing that because it helps them get to a resolution with that.
Yes and no. High Court, yes. Yeah. Chancery, yes. Yeah. They're really cool. Queen's Bench, yes. They're the three courts that I stick to, ideally. You go to County Court, oh man, you get mind fucked there. You know, they really are incompetent, and I hate it. But that's why you see, if you follow my Facebook account, you see how many times I'm at the High Court. Like for example, yesterday I was filing on behalf of a lady called Deborah Ebert, which is this guy's Ebert's wife, with a claim. I took it straight to the High Court, even though I knew it was going to go to County Court. But I filed it there because it gets transferred, processed a lot quicker, and then you're in the system. And this goes back to general litigation, and this is what where I've had a lot of success. Is what I try and do, and how I get into the High Court quite quickly, is look at a holding, look at something I can latch onto in a case. So it could be, I was talking about Sue's case earlier. Yeah. What I did initially, I went for the injunction against the bank. She got repossessed on the house. She had not a hope in hell, because it wasn't even her house, it was her dad's house, who was, sorry Sue, but your he's a retard. In the general sense, he dribbles, he can't talk or whatever. And so she didn't know a guardianship or anything. She left it all too late. So what I did is said, okay, let's get an injunction, which I did. I got it for 4 months. Got a guardianship at the Court of Protection at Holborn, and then dealt with the next phase in terms of administrating the estate, because effectively she had no powers whatsoever. So it's about structure and stuff, but my holding was the injunction. Yeah. To protect the dad,
what
who
can we
couldn't
do
talk.
To give us the time to
just
sort this out?
to find something to latch onto, and that's what I do in all my cases. And I go straight. That enables me to go in ex parte straight into court, and then straight to the High Court.
Yeah. Okay.
And that's basically manoeuvred my position to where now she's in for settlement stages now. With the lender, so she's going to walk away with a couple $100,000 which she didn't know she was going to get, at least at the very minminimum.
Yeah. So that makes a really big difference to her and her father, I should think, as well.
Well, I don't think you'd know anyway, but
but his quality of life will be safe and secure.
Yeah. So basically, she was getting taken the piss out of by the greedy mortgage company. She didn't know what to do. She couldn't get legal aid, and so she was looking down a dark path. And somehow she got in contact with me. And again, go back to my premise of expertise. Mortgages are not my expertise, to be honest. I certainly don't go down the money creation route, stuff like that. Okay. But I've fought similar sort of stuff in court. But I managed to find my holding, which was, I don't know what the hell I'm doing, but I'm going to injunct the fuckers. So that's what I did. Yeah. And we got 4 months. And then I looked at how do we get the exit. And it only took a little bit of time for us to understand, actually, we need the guardianship. We did that. She got the guardianship, well, effectively she could act like a dad. And then basically we're now at the latter end of it, where, you know, in the next couple of months, I mean, she could sell the house tomorrow now. That was a really good court case because the defence attorney for the other side got their ass kicked by the judge, Justice Peter Smith at the High Court. That was really cool because they were questioning everything. But the scumbag mortgage company, they didn't get away with anything. Okay. So that was really cool. So basically, what I'm saying is that's not my expertise, but it's if you put a common sense approach to it, you know, and as long as you're not taking the piss, judges generally look at character quite a lot.
Yes.
And it goes a long way.
Yeah, in terms of how you carry yourself and
I don't believe in the adage that judges are all corrupt. I don't believe that, to be honest.
I was going to ask you now, how do you find the consistency of the judges that you come across?
The problem, the only grievance I have with the judiciary, and this is the main one, is the fact they don't spend enough time looking at cases.
Okay.
That's the thing. It's rush.
Yeah.
And I don't feel sorry for them. But these people are very clever, I'll be perfectly honest, they're very clever. But they're easily misled. They rely too much on barristers and lawyers in the courtroom who will use whatever tactic they can do to try and bend stuff. Yeah. You know, and it's about pulling them back, saying, I don't understand. What's just happened here? Yeah. Stuff like that. And do not, what you don't want to do is if you're on a losing path where it's coming to judgment, do not let that judge do a judgment. You need to stop it. If you're losing, try and get in a judgment. Seriously, just do not get to that stage of judgment if you know you're losing.
I found with the council tax one, because we'd got through one without getting a liability order, we got to the next one, and they went out and had a 15-minute chat or whatever and looked at our paperwork, came back in, kind of acknowledged that there was something there, but in one paragraph, and right on the end of it, he said, and now I'm giving the liability order, and as he's saying it, I'm saying objection. He says, too late, I've done it.
Yeah, you don't want to do it. But council tax is a great one, right? This is what something that I could impart on your listeners is try and get the council official on the stand. They won't. And then what you do is say there's no witnesses here, case dismissed, basically. That's the premise you do. Yeah. You need to get them to go on the stand. And the clerk would normally try and get them to go on the stand, and they refuse. Right, and then you say, okay.
Because I was told I could only speak to them through the magistrates.
No.
That's what they told me in court, wasn't it?
No.
So that's wrong information.
Yeah.
So I need
basically,
to
all you simply say, can I have my first witness on the stand? And obviously the only witness is the pleb that's prosecuting, because it's obviously a private prosecution. Yeah. And try and get them on the stand. They won't go on the stand. And that's how you basically defeat that. And then you go to next April. That's it. Job done.
Okay.
Because they would never go on the stand.
Yeah. And I can imagine with
because I've asked to question them. I haven't said go on the stand, but I've said can I ask questions, and they've said you can ask me, and I will. No.
You need to make sure you say I want my witness on the stand.
Okay.
That's basically it, and they would never go on the stand. Now that doesn't stop you from a civil prosecution, but it stops you from the private prosecution. Right. So providing you steadfast, you're basically walking out that door, and that deals with that issue.
Yeah. Have you ever come across or some people when they go to court, they get the impression that everybody's against them?
Yeah. That's pretty much the case.
Well, yeah, it can often be the case, but I've come across quite a few people who've had quite a bit of success illustrating some of the prosecution's weaknesses, and this is what you've done very well in the past, is showing some of the prosecution's fallibility, and that way you make the bench less sympathetic towards them. Have you found that dynamic working in court at all?
I think you mean it. You know that they're there to judge somebody, and if you can move it, shift the burden onto where it should be. The burden of proof is on the prosecutor, so if the judge is then looking at the prosecutor, it takes some of the pressure. But I don't know if that always is the case.
I mean, I suppose in essence, obviously the burden of proof is always on the prosecution or the person making the allegation. But what you've got to... The obvious answer is you want to make them look like a complete freaking idiot. Right,
or at least not competent.
Yeah. And you haven't got a case to answer, and it's almost like, what the hell am I doing here? Right, that's the obvious answer, right? But basically, what you try and do is let them talk for England. What you find, and I don't know if you've witnessed this yourself in court, is what happens is the prosecutor says very little, especially at magistrates, and the guy who's the person liable, I say the guy, male, female, whatever, the talks for England, and they just end up in a pickle. Now, if you just say, for example, like I say, where's the disclosure, and just sit there silent, that's all you're going to do. You know, just don't go talk, say I'm not guilty, I'm guilty, whatever. Just don't. Just say I can have disclosure, then I'll make a decision. Yeah. I'm a litigant person. I'm an idiot. You know, I need. But what you find is, and I use it a lot in court, specifically at the High Court, for example. I always play to the court. Like, for example, I do not believe I can assist the courts any further in this matter, or if the courts require, I can call this witness, or I would like the courts to do this. So, for example, so you're playing up to them, the theatre of the courtroom. Magistrates, it's like a convention.
The other thing which I've noticed that sometimes happens when people are in court is that they can feel like it takes a while before they get an opportunity to speak. So when they do get an opportunity to speak, they try and say as much as they can in one go to almost plead their entire case all in one go.
Well, to be fair, going back to my previous point, is what you want to do is say as little as possible, especially early on, because what you're pushing for is disclosure.
Yes.
So who cares what they've got to say? Where's the evidence? That's it, and that's what you stick to. Let them, you know, break wind, so to speak, and let them expose whatever they've got, and it's inevitable. I mean, to be honest, prosecutors nowadays, and especially at magistrates level, you ain't got to worry about them. They're so incompetent, it's unbelievable. Yeah. Like Crown Court gets, you know, obviously you're embarrassed and that sort of stuff then, and they're a bit more cleverer, and they do a bit more due diligence. Their paralegals are a bit better and that sort of stuff. Where CPS lawyers at magistrates court, they don't have prep, all they have is administrators. Yeah. Where at Crown Court, there's obviously a little bit more effort that gets put into it.
You have a legally trained bench, or you don't. You know,
So basically, your objective is a bit like the principle when your first interaction with the police. You say nothing. When it goes to magistrates, you say nothing. You want them to disclose everything. You even open your mouth could allude to something, like, for example, saying I wasn't there on that night. Why even bother saying that? Let them prove you were there. You know, that's what you do. It's just you've got to keep your mouth shut all the way through the process until you get disclosure. And then you look at it, I'm not joking, the amount of stuff that I've seen on disclosure, it'll make you laugh. I mean, I've even had cases where I've been given disclosure, it doesn't even relate to the person it's involved in. Okay. You know, so, you know, it really is. I mean, a perfect example, one of the witness statements I read, this is probably December time, the suspect, the alleged suspect, the guy that was being prosecuted, was 8.5 metres tall. That was in the witness statement. And that's got to be pretty good going. Yeah. That's probably the tallest man in the world, I reckon.
Oh, easily.
They don't need to do an ID parade.
So, I mean, it's stuff like that. But you wouldn't know that until you get the disclosure. So, as long as you get the disclosure, you know what you're dealing with. And you can always plead guilty then. You know, do that. Yeah. If you feel you're guilty, you're guilty. But if the evidence is not there presented before you, obviously you want that. You want to do that, and you want to protect your position, reserve your rights. You don't want to prejudice yourself or your family, because the impact.
You want to be as well informed as you possibly can.
And it's only fair.
Do anything.
It's only fair.
You're legally entitled to be.
Going back to the basis principle of, if you employ a plumber to install a boiler, you want him to install a boiler. If that doesn't happen, then you know that you've got an issue. Yeah. It's a bit like prosecution as well. You know, the prosecutor's saying you did this. You possibly believe you didn't do it in that order or that fashion, or the way they describe it, then you litigate. But if you did, for example, I hit Fabrice Friday night, I shouldn't have done that, it was wrong, then I've then got to take my own accord to whether to plead guilty or not. Yeah. But if, for example, Fabrice hit me first, I need to litigate that position, because it's not as simple as they describe. Because for example, if there's a fight, the police are obliged, so they say, although we all know they're not obliged to do anything, is to arrest somebody or remove someone from that situation. A bit like domestic violence, that sort of stuff. But it's about getting that disclosure, and then it is, in some respects, it's quite converse, in as much as that if, for example, a domestic violence case, it's often difficult for the police to make decisions on the ground just like that. But if you take my example from a couple of weeks ago, where the police officer just flips it and says, okay, trespassing, he obviously knows that I know trespassing is not a criminal offence. It was an aggravated trespass because I wasn't in the property at the time. I wasn't even on the property anyway. I was outside of it. He said, okay, I'm going to arrest you for attempted burglary. Now, that's perverse. That's just ridiculous. And so he had options then. He could have just said, okay, be on your way. I mean, what he didn't realise is I recorded the whole event.
Yeah.
So, but I didn't tell him that either, though. By the same token, but that's, for me, is nonsensical. But it happens every day.
Yeah.
Yes.
And
Now,
whereas if he, I haven't seen the video clip. If he just says, you know, okay, well, you know, maybe you might be on You Being Framed. You know, you're done now. You know, go and see if Jeremy Beadle's interested in your wares.
Yeah.
You know, and nothing more than anything of that nature. You know, it's like if somebody's singing a bit too loud down the road, you go, hey, keep your voice down.
Yeah.
On your way, and that solves the problem. You don't go, hey, breach of the peace, get a truckload of people, take them down, throw them in a cage for the night. And that's I think because sometimes that does happen, and people feel that bureaucrats and police, sometimes security, and judges and magistrates have that kind of power, and sometimes they hear those kind of stories. Some people can really scare themselves and take themselves out of their sort of functional zone before they get in there.
This is, I mean, this goes back to the police state issue, because I have a big grievance with this sort of police's attitude, to be honest, right? And it's fantastic to just watch a police officer. I say fantastic, but I'm being patronising. Is they really are corporate enforcers. Like, for example, I was speaking to a police officer a couple of days ago, and this was with a bailiff in attendance. And I said to the police officer, I said, why are you reading the bailiff's paperwork? I said, what has it got to do with you? I said, I'm telling you, you shouldn't be there. We don't require your service. Please be on your way. But he's saying, well, there's a warrant here. I've got a warrant, and it enables this guy to go in the property. And I said, okay, fine. Let him go in the property if he's willing to let him go in the property. But the fact is, they're now acting as policy enforcers for corporations. Perfect example was, you know, Peter Glasgow's injunction, is where the police were in attendance both times. Why are the police there? He did not call them. Okay. There was no threat on him, by him, to the British Gas guys. He's just saying, up yours, mate, you're not coming in. Yeah. You know, because there's no lawful reason for him to be there. But the police come along, and they come with a battering ram, and lay it on the floor. I mean, how intimidating is that? And what has it got to do with the police? It's a civil matter.
And they should be there to protect the peace. That's
they should be there to protect Peter from them. And they've reversed it completely, and they don't even understand it.
It is. I mean, it was interesting. We had the opportunity to question police in that position when we were outside the Quadrilla rig in Bolcombe,
where they marched around the lorries.
Fracking,
yeah. Where they marched
so you had commercial lorries
in
coming in and out with a police escort that most prime ministers would be. You know, you would think it was overkill, and it's part of that mentality of we do what we're told. Which, of course, the antithesis to that is the philosophy that you're ascribing right at the beginning of the interview, which is ask questions. Yeah. Ask them, you know, what they're doing. Do they know why they're doing it? Do you know why
and don't be in their face. Just remain professional and calm. You know?
That's what we.
You know, but saying that didn't help me on that night where I got arrested.
But we do try and we call it charm offensive sometimes. Yeah. We're very polite. We're very, you know, we don't go in there and get angry with people. Occasionally it happens, doesn't it? But you know.
But going back to court and legal land, moving forward, I suppose. Sorry for talking over you, Fabrice. But I think what people need to really focus on is the facts against them. That's really it. And I know I keep on saying the word disclosure, but it's so important in everything in life. Yeah. Like, for example, relationships. You want to know your partner's faithful or not faithful. You want to know that, you know, dinner's going to be there, whatever, or who's doing dinner that day.
Yeah,
it's the same. Yeah, it's the same sort of thing. And don't. And this is what I see quite a lot. People send letters to the court. Don't worry about sending letters to court. Copy them in on correspondence that's pertinent. But if you've got a matter that needs to be dealt with, you need to make applications to the court. You need to make mention hearings in magistrates' court. You need to do it that way. Don't just write a letter and expect it to be replied to. What you need to do is, if something requires a response or it's for your information, you just file it. You say, here's a copy for the file. Yeah. But if there's something that requires an action, don't expect a letter to be replied to get that action. You need to make an application, and unfortunately it requires money. But a lot of people I deal with benefit from fee remission. So
And what's fee remission for?
It means
for
you haven't got
people
to
who
pay
don't know?
court costs.
How does one go about?
Well, if you're on benefits, or if you're on a low income, 3 months bank statements and proof of benefits. That's it. It's EX160, straightforward form. Just fill it in, and then you get it stamped by the fees office. Like I say, I do everything in the High Court, even though I know stuff is going to go to County Court. I do it all at the High Court. That way, it happens quicker. Going back to what I'm saying about my holdings, for example, if I can latch onto something, an application of some sort, in order to get a case going, like in Sue's case, for example, she didn't have to pay a penny. But we didn't even do fee remission, we just went straight into court. Carla Buckle's case, when we got her out of prison, I didn't pay a penny. I just went straight into court, didn't have to do fee remission, any applications, nothing. I just went in with my bundle, and that's quite important. I don't think we're going to have time to discuss all that, but the presentation of paperwork, however minor the offence or allegation is, or the complaint, it's really important. Yes. And as long as you can get the foundations right, you're good and all set.
So I mean, a well prepared bundle can make all the difference.
Yeah.
And sometimes it can give you, again, that extra bit of confidence and a surety when a legal clerk is looking for a piece of paper relating to an element of the case, and you already have copies of it and you can point them to it. Then again, I think it's part of that respect that actually it costs nothing, and if you use good manners and you do have that politeness, even though you can be very assertive in your questioning, I think that does carry quite a considerable difference.